Okay, can somebody confirm if it is already?
Yes, we can see. Yeah,
Thank
we can
you.
see.
Thank you very much. Okay,
Just make-
Bismillahirrahmanirrahim. This is co-written by Professor Ida Madiha Abdul Ghani Azmi and myself, both of us from the Civil Law Department, Ahmad Ibrahim Kuliah of Laws, and this is also part of our ongoing research. The title is Like, Comment, Share, and Guilty as Charged. Why social media users should relook at Section 233 CMA 1998. A little bit long, but somehow it was necessary just to highlight what is it that we are trying to say. But I believe all of us here, regardless of our age, we already are getting familiar with these phrases, like, comment, and share, like, comment, and sometimes they also add on with like, comment, share, and subscribe. Yeah, don't forget. Yeah? So every time before you encounter and open any online content, then they will tell you, or there is a notice to please like, comment, like, share, and subscribe this content, especially on the social media. So the idea behind this paper is, of course, it is also to be streamlined with the objective of this conference on family law, family justice, and Maqasid al-Sharia. We understand that this topic may cover the very wide audience, either Malaysians and people outside Malaysia as well, universally. But it is true that now our youth are very much occupied with these social media interactions. It is their lifestyle. They are called millennials because they are also called digital natives, because this is the life that they are going through in social media. So no day without going into the social media, interacting with social media, and some more with this pandemic. We see the drastic. The statistics show us a drastic use and increase, yeah, of the social media from time to time. So we are highlighting a very specific area in the social media, which is on the offensive content. And it may not be the first time for most of us to hear about Section 233's Communications and Multimedia Act. But what we are highlighting here is we contextualize the provision of this act into the environment of the social media where our youth are very familiar with. So in the presentation agenda, as you see, some of the steps that we are going to cover. And then this is the abstract where you can see the background, objective, as well as the credits. The use of social media is a norm of communications today, especially among youth in Malaysia. Yes. And the activity of creating, publishing, and sharing of digital content through social media may lead to some legal consequences based on the laws currently enforced on internet, social media, and other areas. This is made a very critical as well, because our youth, yeah, being youth, they may not necessarily put this as a priority. Maybe they have heard about the law, but they don't really put, appropriate or proper uh, focus or concerns over the legal consequences. All what they know is just to simply use the social media, but then somebody has to remind these people, especially parents, especially teachers, educators. We need to remind. We don't want the police to remind them, because that means they are already in trouble. But we hope with this we remind educators as well as parents, yeah, to keep on observing and advising our youth about the legal consequences of their social media interactions. This paper sets as an objective examining the extent of the application of Section 233 of the Communications and Multimedia Act on social media related offenses. Yeah? So by doing that, we are highlighting from the cases that had been recently used or decided in Malaysian courts. Even though not all those cases involve youth, as a matter of fact, either as accused or victim, yet they provide helpful guidance for all members of society who increasingly adopt digital lifestyle. And this case-based study is ultimately significant to help us understand the implications of law. We'd like to acknowledge that this study is funded by the IUM research grant under the Research Initiative Grant Scheme publication. And we see as a matter of fact, that the statistics keep telling us and reminding us how massive the interaction is on the internet from time to time, from hour to hour, even from minute to minute. There is already this statistic in 2020. What happens in 1 minute on the internet? This is on the global average. As you see, just an example, just to give you the sense of how massive the interaction in the internet is. We all use WhatsApp, for example. Well, how many messages are shared in 1 minute globally? I mean, we see 41.7 million messages. So as we sit here today, already like 2 hours, you can count like how many messages are there on WhatsApp. And what about Instagram, the second popular after WhatsApp or for instant messaging? 347,000 stories are being shared on the internet. Then TikTok, of course, TikTok now is also making news. Um, it's they are being massively installed. Yeah, in 1 minute, 2,704 installations of applications of TikTok. So this is really a massive data, a massive situations where we don't see cyberspace as a quiet place. It is a very um, a dynamic situation. So you can expect, and even for Malaysia, of course, the same thing. It's not exclusion. You can expect that a lot of things are being said and being, communicated in the Malaysian cyberspace, and you can expect that some percentage of those expressions may come to a certain extent to trouble when we consider the laws that are enforced in Malaysia. So we have few statistics as well in Malaysia, and I'd like to highlight to you perhaps to the one at the bottom, which is for Malaysia. You see the one at the bottom right here, how digital Malaysia outlooks is in 2020. You see, our people, they spend about 3 hours and 37 minutes on their mobile, for example. This is the daily average. So you see more and more statistics telling you that this social media is getting larger and larger by the day and by every time you see, and it never decreases. So I think we have to be more ready. I followed one of the presentation this morning, also saying, having this statement that the more technology develops, then the more we're going to see how the expression of talak is going to happen before us. It used to be by phone and by mobile phone. Now people are also expressing talak by Instagram. This is happening already in Malaysia. So this is what we see as coming. So this paper questions a few things. Number one, what are the laws that regulate the usage of social media in Malaysia? This we can say that lots of laws actually, but I am going here in this paper to discuss one particular law, which is Communications and Multimedia Act, and in particular, this one section which has been frequently used by the courts, which is Section 233 of the CMA. So we have this question whether Section 233 is constitutional, because from time to time, I repeat, from the very beginning, even to a very recent time, that we will see cases where people challenge this CMA, and where people challenge and questions the CMA of its constitutionality. The main argument is whether or not this is a restriction to a violation to the freedom of expression. We will see some discussions to that. And then what amounts to offensive content in Malaysia, as well as when it comes to Section 233, how it applies in the context of social media. So in general, Malaysia is not a lawless country when it comes to the internet, cyberspace. Never Malaysia is a lawless country. Even though back in 1995, 1996, the government kept on, or rather started this, campaign of no censorship policy in Malaysia. And this was very much related to the multimedia super corridor project, because Malaysia was wooing investors. We want to tell them, come here, invest with us, and don't worry that we are actually very, we are very modern in terms of our thinking. The internet is open. We're not going to censor the internet, and we ensure the freedom of expression, also the right to data privacy, as well as we make sure, any attack to cyberspace is going to be criminalized. That is back in 1996. That's why we have series of cyber law legislation since then. But even though the government say there is no censorship, no censorship policy over the internet in Malaysia, that does not mean at all that we are keeping quiet if there is any, violation of rights, as well as abuses, in Malaysian cyberspace. Because as a matter of fact, from the act itself, which says in section 3 that there is no, not meant to be a censorship, but also in section 263 of the same act, which is Communications and Multimedia Act, the government actually allows, has this power to direct service providers, like ISP, like the telco providers who provides the service to the internet, to take certain actions that is necessary, such as blocking the internet, blocking the access, such as the blocking the access. So if you realize that certain websites, for example, are found to be offensive in character, abusive of law, as well as creating, disorder to the public, actually the law allows, mandates this, the government to force the licensees, to block the website. So it is not a lawless situation. And at the same time, we have laws to impose criminal sanctions. CMA is only one of them. We have other laws such as penal code, such as Computer Crimes Act, and then Sedition Act even being used one way or another. And at the same time, we also encourage, industry to do the self-regulatory mechanism. We mentioned this, I think my colleague, Dr. Mahyuddin, yesterday was explaining about some aspect of this self-regulatory mechanism when it comes to cyberbullying, even though we do consider the self-regulatory mechanism is much, much, softer than the law, but maybe to some extent it serves some purpose. So this is the situation of internet governance in Malaysia, and this is the main act that becomes the basis of our paper. As you see here, Section 233, this has been used in many cases in Malaysia against people who are misusing the internet. Yeah, for example, posting messages, posting, comments. Yeah, that's why the title of this paper is Share, Like, and Comment. So in each of this, you share, meaning you are actually communicating a communication, even though such communication does not originally come from you, but the moment you share it, it can technically, it can be considered as creating the communication itself, because you are creating it over your own account. So that has been the interpretation. What about a comment? Of course, when you make comments, then you are making a content. What about like? This is very interesting. Can someone be uh, jailed? Can someone be guilty just because he likes something? I don't know how many likes you have put on Facebook, for example, today or this week. Maybe there are so many likes. Yeah, but then this is, I would say, quite a gray area. But there are situations where your like might be considered as a support or as a uh, giving the support and giving the or promoting things, because technically speaking, when you like something on Facebook, for example, you actually makes it notifiable to other, to your friends. Yeah, I don't know if you realize this or not. There are so many postings on Facebook, for example. On Facebook, we say, of course, some of those postings only appear in you because they are from your friends. But the moment you put likes on some of them, you like them, and then you actually create a chance, technically, that your friends may also have idea of what you like. So this is also a gray area where we don't have a case law yet, where the like itself can be considered as an expression. But in this paper, we argue in positive, because like means you know that you are actually liking it, and you are making it known that you actually agree. So some people argue that, okay, then from now on you have to put on your Facebook page some disclaimer, meaning when you like doesn't mean that you support. This is, of course, the lawyers thinking like that. If you have that, maybe it is safer. If not, then it can be somehow put against you that you like it. Especially when we talk about law of terrorism. In Malaysia, we have under penal code, which is not in this paper, but on the same sentiment and principle. Um, there is this specific law under Section 130, Clause J, 130J, saying that it is wrong, it is an offense to support the act of terrorism, to support terrorists. And by support here includes that support in social media. And this can be interpreted further. How do you support someone in social media? Yeah, even though it doesn't specifically say by putting like you support, then we don't want to be in this shubhat area. Of course, for the lawyers, game on, you have to fight. Yes, of course, that is how we do. But if we are to advise our children and youth, yeah, don't do that. You see bad postings, you see bad contents. Why should you put like on it? Maybe you have different meaning of like at that moment, but then what people will see when you put like on it, or when you put love indication on Instagram, for example. So this is something that we have to, I think, better advise not to do that to our children. When it comes to this section 233, the specific act is very clear. When you make, create, and solicit, sometimes you see solicits can also be interpreted widely, because we don't have a clear interpretation of what amounts to solicit. Yeah. But this actually opens room for the interpretations. Yeah? So that is the problem. If the law does not interpret specifically on certain words, that means it is the battleground, yeah, for the lawyers, for the solicitors, for the advocates to argue in courts. Okay, this is about section 233, and then there are questions about constitutional of the CMA. As a matter of fact, we have had quite many cases where people argue that this section 233 is restricting the freedom of speech. But every time this case appears, the court had come up with, more and more confirmation that there is no unconstitutionality here, meaning there is no issue in terms of constitutionality, because this CMA is necessary. You see, we have, for example, Nur Hisham bin Osman versus Banda Oraya in 2010. You see down there, this limitation is both necessary and expedient in accordance with the objective put up by the Constitution itself. Yeah. Then in Sharul Ima, this is a later case in 2018, the courts say that this section 233 had passed the test of clarity, limitedness, and proportionality. So you cannot say it is unconstitutional. There is this test and criteria. And then in the much latest case, Muhammad Fahmi Reza bin Muhammad Zarin was lawan pendakwa raya. Also, the court says that this is you have to go back to the law. You don't say just because it is an art, it is a parody, then it should be free. No, you have to go back to the principles, the main principles, and it is for the court to decide whether or not it is uh, a violation of freedom of speech. And in all these cases, the court said that this CMA is not unconstitutional, meaning it is constitutional. So this will be the last page where it gives a few issues or few points here on the in the context of social media, how we contextualize Section 233 CMA. Number one, yes, this Section 233 is applicable any platform because it is a platform neutral law. You can name it by email, by blog, or by wiki page, or by social media. Now we have lots of types of social media, video sharing, text messaging, and then social networking. You can name any of those. They all apply. It doesn't matter. Whatever platform you are using, this CMA will apply. Then also about the use of emoticons. I think this is similar to what we have said about the gesture of likes and love. So emoticons at the same time is also an expression. Yeah. You see, when you text your friend without emoticon, it will be very dry. But the moment you type something with emoticons, it can be very, very, dynamic. You put smile and different types of smile, and sometimes laughing with tears. All these are considered as other types of communication. So you cannot simply say, "Oh, I just put emoticons. I didn't say anything." No, this emoticon is what you said. It represents what you said. So we can have this as also another points when it comes to social media. Then what about copy pasting? The argument, or this is one of the most many arguments people made. I only copy pasted from my friend's page and now I put it on my friend. Is it amounting to my communication? The answer is positive. Yes. Yeah, because as we actually argue from the meaning of the law, as well as from some cases, we see that yes, it doesn't matter whether the expression comes originally from you or actually you are copying or you are copy pasting. It is still your communications. Yeah. Okay, there's another issue here. Somebody posted on my Facebook or on my blog, which is not from me, sometimes it is possible because people put on comments, right? People put on comments, and sometimes people comment on people's comments. That is what the Web 2.0 is. It allows a very dynamic, interactivity. So to some extent, you argue that I cannot control. No, the fact is you still can control, right? The fact is you still can control because you may want to, if it is not really from you. Now the problem is some people say, well, I've lost control on my page. Somebody actually has hijacked it. Or now happening that people hijack your mobile number to make it as their WhatsApp number. So they started to, send requests, for money, defrauding activities and so on. And you say, no, it's not me, but it is your number. It is registered as your number. So we have this now, these laws saying that under Section 114A Evidence Act, it was controversial actually, but it says that if it is seen to be from you or under your name, which is registered under your name, then it is going to be presumed as published by you. So what you need to do is to rebut that. You cannot simply say, no, it's not me. No, it's somebody else did it, but you have to rebut it properly. Why is it not you? The onus is on you to actually argue that it is not me. Yeah. Otherwise, then it will be inferred that it was your publication, and therefore you have to answer in court about the content of that. That is also another situation. Yeah, I think I come to the last, and my time of 20 minutes is over now. Let me just put my last point. Right, when the Section 233 says that it is one of the element is the communication with the intent to annoy people, the intent to harass people, the intent to make people, angry. So the fact that that person, that victim is not angry or is not annoyed does not make you automatically not guilty. In other words, this section 233 does not require the occurrence of that intention. You intend, let's, for example, we infer you that you intend with this communication to make the king angry. We have this case, PP versus Rutinin in 2013. He wrote something against the king of Perak, Sultan Perak. Yeah? Then he argued. Actually, even Sultan Perak himself was okay, was not disturbed. You have not proved whether he is actually annoyed. The court say no, this is not required. It doesn't matter whether the person is annoyed or not, because it is not the elements required under the law. Right. So what we have covered here is that we have contextualized Section 233 in the context of social media that people are currently, especially our youth, are currently doing. So in this conclusion, as I said, this paper recontextualizes Section 233 in the context of social media. It also discusses the judicial guidance derived from some latest cases decided in Malaysian courts, as well as calling the Malaysian digital society and youth especially to be more responsible in using social media to reap the best of the digital economy. And this is a bonus judicial quotes for all of us from the case of PP versus Zainuddin. Datuk David Wong, the judge, highlighted to us in this day and age of the internet, where the free flow of information from cyberspace, young people are exposed to things which the older generation could not have imagined. This is very true. We never imagined as a child in the past would have seen things that our children today have already seen. Isn't it correct? So this is really a big challenge to us. Such exposure had no doubt, that this is what the court said, also made the art of parenthood much more difficult in dealing with such social issues. And in some cases, it had made it impossible. So this is really a good reminder for all of us that perhaps the real battle is not outside our house. The real battle is happening inside our own houses. That will be the last thing I want to share. Thank you very much. Terima kasih and syukran kathiran. And my co-author, Professor Ida, would like to convey her best regards as well to everyone here. Thank you. That is it.